Regulation 1049 is something that I've been working on for a very long time. I actually got interested in the topic already before the regulation was adopted. I was then working on my PhD for almost 20 years ago. And then, since then, this is a theme that has somehow been coming back to me over and over again in different sort of roles and formats. I have a background as a civil servant in the Ministry of Justice in Finland, which basically means that handling information requests is something that I've been doing in a national capacity for many years. And I know that it's a very difficult task, even when you're dealing with a detailed legislative framework, as we have in Finland, but also a sort of relatively strongly anchored tradition of transparency legislation. But I've also been involved in managing the 1049 framework for a very long time. When I was working in Finland, I was the representative of the Finnish government in the working group on information, which meant that I've been handling many of the information requests directed to the council for many years. And also when Regulation 1049 was up for review, you know, there is a sad story of negotiations that lasted for a couple of years and never came to a proper closure. I was the Finnish representative in those negotiations. So in that sense, during that time also saw the dynamics of this issue. We see that this is an area where national traditions very much play in, but you also learn to know the many people that work in the institutions, and many of them are extremely good people, interested in promoting transparency and finding solutions that are not only in line with the greater ambitions of this framework, that is democratic participation, turning administration more legitimate. You have all these ambitions in the preamble of Regulation 1049, but also concerned about finding practical solutions that can be managed and that are not overwhelming on the institutions who need to deal with them on a daily basis. During that time, I was also involved in quite a few of the court cases that went on during that 10-year period, because the Finnish government was quite active in intervening in court litigation that time. So I've been involved in writing many of those pleadings. And then since then, I've become an academic again. So I work as a professor. I lead a research group of 7 people who looks into transparency in the EU. And while doing that research, I've done quite a lot of applications, again, directed to the EU institutions for documents that are relevant for my research, for research done by my researchers. And that has also turned into a court case, which is now before the General Court, which is wonderful because, of course, every EU law academic should have a court case in their own name. I have one, which is very genuinely produced by my research against the European Parliament, and also a few court cases that are before the European Ombudsman relating to documents that we would have wanted to have for our research, but which we didn't get for one reason or another. Now today the title that I got is broader, and when I saw it I was a little bit concerned at first. I was thinking, whoops, because the European Convention is something that we don't actually talk all that much about in the 1049 context. We talk far too little about it in the 1049 context. So I'm actually very thankful for this invitation to sort of look into the issue from a slightly broader angle. And while preparing, I actually got so excited about it that I recruited another researcher just to look at the issue of what the European Convention should bring into our understanding. She will start next fall, so thank you for that idea as well, because I saw that in fact there are a lot of issues in there that we haven't properly considered. So sort of what I've planned to do now, I've been asked to set the scene, and that's what I hope to do. I plan to talk a little bit about the European Charter of Fundamental Rights, and then the European Convention on Human Rights, the jurisprudence, some of the core ideas, objectives, and standards that come from the European Convention, and then come back to Regulation 1049, where I see that the implementation of the regulation could and also should be improved, where the big problems are. And finally, I would want to talk about harm, because harm, in fact, is the core concept behind 1049. And a great deal of FOI, Freedom of Information, legislation in general, in the sense that the basic logic usually is that everything is accessible, everything should be in the open, unless disclosure will result in harm. So, of course, considering that harm and evaluating that harm is where basically everything comes down to, and that is maybe where I have some concerns when it comes to current institutional practices. Especially since we're stuck with the regulation that is becoming rather outdated, which is then filled with other ways of managing issues instead, and not all of these are always that transparency minded. Good. And then, actually, finally, I think all of this will then contribute to sort of, I won't be able to stay for tomorrow when we have a panel discussion about where things should change, but I hope to sort of lay out my own agenda for change, where I see the matters that would need to be addressed in this framework. So basically, I think before we start talking about Regulation 1049 or access to documents in detail, I think it's good to keep in mind that what we're basically talking about is the principle of openness. And the principle of openness is not only about access to documents. Access to documents is extremely important, but it has other forms as well. We've got access to documents, which we find in Article 15, and we also find that in the Charter of Fundamental Rights. But it's also linked to publicity of procedures. So you also need to know how decisions are being taken. And that is, I think, something that is often forgotten, that for individuals looking for documents, I know many researchers, for example, who would be very interested in knowing more about the EU and getting access to documents. But it's difficult if you don't understand how the procedures work. So it's very much linked to that as well. Then we've got the question of communication. And these are often sort of, I think they're often a little bit mixed, that there is sometimes a tendency to think that as long as you have a good communication policy, you don't need access to documents. But these I see as completely different issues. Of course, the institutions should have good communication policies as well, but it's a different issue from public access, and I want to come back to that later. And then finally, we also have good data management, which is also linked to access to documents in the sense that information needs to be easily obtainable. And I think that is an area where the institutions have a great deal of work to do. That often you see requests for information being denied simply because it seems that the institutions don't necessarily know whether they have the document or not, or simply that you see that finding this information is extremely cumbersome for them because their systems don't seem to be operating all that well. So it's also definitely tied to the question of public access. Now, Regulation 1049, it's been in force for quite many years already. And as I mentioned, there have been 2 Commission proposals attempting to revise this regulation. It's partly because there is a great deal of case law on the regulation already. Many cases brought by individuals, by NGOs, by researchers, and so forth, which have developed our understanding of this regulation, but also showed where perhaps more specification might be needed. Another issue there is that we've got a new treaty in force. We've got the Lisbon Treaty, which is no longer a new treaty, has already been in force for quite many years. But one of the specific background assumptions of this treaty was making the EU more transparent. If you look at any of the political speeches given around the time when the treaty was ratified and approved, the issue of transparency was very high on the agenda. And there was an assumption that the EU would become more open. And there is, of course, some difficulty there when we have the secondary legislation, Regulation 1049, is older than the treaty, and the treaty hasn't, or the regulation hasn't been updated to correspond to the new treaty framework. So that's another issue which the institutions have then needed to manage in other ways. And where, in fact, the court has done some of the updates, especially in the area of legislative transparency. And that's something I want to return to later. A final point relating to the Lisbon Treaty then, of course, also relates to the Charter of Fundamental Rights, which became legally binding on the institutions at the same time. And the links that it makes with the European Convention on Human Rights, which in fact would also create additional reasons for looking into the legislative framework once more. I know that there are many of these issues are issues that you will come back to in detail during the following 2 days. But I tried to make a list of issues that I found have been particularly contested while the regulation has been implemented. A key issue relates to legislative transparency. There are some issues there that have been challenged before the court. Access to member state positions in negotiations, legal advice has been legal advice given in particular in the context of legislative procedures is something that has come up repeatedly. And also the question of space to think, how much that should be protected, in particular in the legislative context. Another issue relates to the definition of public interest. And public interest is, of course, it's a core issue in the regulation, because when assessing an application, the institutions usually would also need to consider whether there is a strong public interest in disclosure. There is fairly little in the court's case law on what this public interest in fact means, and it has remained largely undefined, which makes it quite difficult for individual applicants to in fact refer to this public interest, because nobody seems to know what exactly it means, apart from linking to the broader objectives of transparency that the regulation builds on. The question of data protection and privacy is a key issue, and there you of course immediately see a clash between public access and transparency on the one hand, and then the interest of protecting privacy and data protection on the other. We have issues relating to, in particular, investigations. And there, I think the broader issue, or one of the broader issues there, is that under 1049, the institutions have, in fact, needed to deal with a lot of applications that are more closely tied to private interest, to individual files, cases that individual people have pending, or companies have pending, for example, before the European Commission, which in fact are not public interest files in the sense that Regulation 1049 understands them. These are more cases of access to one's own file, people who, for example, need information about what's in their file for the purposes of defense. The logic there is slightly different. Access to one's own file is a right that we find in the Charter, but it's a separate right. And yet, quite often, that is a right that is perhaps not properly protected. There is no privileged access to one's own file under the individual procedures. And therefore, many individuals try to get access to their own information through Regulation 1049 and make very big requests for information, which is something that the court has needed to consider as well. And from that comes an understanding of general presumptions, which is something that the court has developed, which basically creates areas, especially in the area of investigations, where the institutions can presume that documents will not be made available. This is a policy that I have serious problems with, but it exists there. And I also see the issue with very large applications coming in that don't necessarily have a public interest dimension as an issue that would need to be tackled somehow. One of the big issues also relates to court documents. There we have court jurisprudence in the background, but there is relatively widespread concern about the lack of access to court pleadings. This is an area that has developed in case law and which you will hear more about today. Then, of course, Regulation 1049 is not the only piece of EU legislation that deals with access to documents. We've got hundreds and hundreds of pieces of secondary legislation that also make reference to 1049. Or that have general references to professional secrecy, for example, without necessarily explaining how the two issues are compatible. How do you combine issues of professional secrecy with access to documents? And since, of course, new legislation has been adopted, this amount of secondary legislation that deals with access to documents questions as well has been increasing. And there are elements, many pieces of legislation, where you in fact see additional elements to 1049, or elements that are not easily combined with what 1049 tells you about access to documents. And there we see problems emerging with these different sort of general rules in 1049 and the specific rules included in other legislation, how they should be put together. Many national administrations also tackle 1049 issues, and I think this is an increasing problem, or challenge at least. I get many inquiries from national authorities wondering what legislation in fact is applicable. You start from a sort of basic assumption that for the EU institutions it's 1049, and then for national administrations it's their own national legislation. But that is not quite that explicitly cut, and that is a sort of limitation that is often difficult to manage. There are further issues that could be added to this list: international relations, security, for example. But I actually didn't put them there, even though we've had quite a lot of litigation on those issues as well, simply because I feel that in the area of international relations, for example, jurisprudence has been going to a rather positive direction, and I didn't see that very much as a problem anymore. It probably is a challenge still, but less relevant to me personally than many of the other issues on this list. Now, why would the Charter be relevant for any of these? The obvious answer, of course, is that the Charter of Fundamental Rights includes an article on public access to documents. That's the easy answer. It's very much the same as Article 15 in the Treaty on the Function of the EU anyway, but there is an article on that. But in addition to that, it includes other helpful references that a sort of more pro-transparency minded person could build an interpretation on. And I think there, in fact, duplicating Article 15 it has more to it than just repeating it, simply because it does uplift access to documents to a fundamental right. And with that recognition also comes something that is recognized in the final articles of the Charter, which is the authority's general obligation to promote the observance of fundamental rights. So it's not enough to be passive. You actually have a positive obligation to do things that promote access to documents. And I think this is easily forgotten, that it's not just that you sit still and you wait for citizens to approach you, but you in fact have a positive obligation to take measures in order to make this right a reality. And then, of course, in the Charter, in the end, you will all be familiar with this, but there are provisions stressing the equivalence of rights recognized in the Charter and rights recognized in the European Convention on Human Rights, but also other international agreements. And I think this is an element that we really have not considered seriously. And I remember that during those 3 years or something that we spent on trying to revise Regulation 1049, I cannot remember that we would have discussed jurisprudence from the European Court on Human Rights more than in one occasion. There was one element in the regulation where arguments about the Strasbourg jurisprudence came up, and that is the context of discussing privacy and data protection. And I'll come back to that. But I think there are issues reaching beyond that, where this jurisprudence would be very relevant. It is interesting that there are cases that have been pending before the Court of Justice. The case brought by Professor Besselink is one example, but also cases relating to data protection, in particular 2 Dennekamp cases, where arguments about the European Convention and the relevant jurisprudence were very strongly brought up by the applicants, but the court never really sort of took them up, and they're not incorporated in the court's rulings. So in that sense, I hope this is something that would become stronger in the future. And I think there are instances here where we can see that the protection that the EU is currently offering, I think, falls below the standard that the European Convention would in fact require. And one element there relates to the whole idea of considering public access in a very strong democratic society dimension, and what the democratic society requires from public access in order to be real. This reaches beyond the European Convention system. This is an example from the Human Rights Committee, which I also find very interesting because it has this same idea of positive obligation, proactive policies. It's very clear on the point that states, in this case, should proactively put in the public domain information, and they should make every effort to ensure easy, prompt, effective, and practical access to such information. So again, the same idea, you can't just wait passive, you have to go out and make information easily obtainable and be proactive, not just about responding to access to documents requests, but also making that information available so that in many cases perhaps these applications are not even needed. And I think this sort of links with the idea in Article 51 of the Charter as well, the idea that authorities have a positive obligation to make information available. Now, in the European Convention, we don't actually have an article saying public access to documents. It wasn't thought of at the time when the Convention was created. But this is an area where we've seen huge developments during the past years, and in particular for a year ago when the court addressed a big case brought by, there are actually 2 of them, but the latter one is the more significant one, brought by Hungarian human rights organizations, where the court very clearly says we have a right of access to documents emerging in the convention system. It's based on some of the articles in the convention itself, the articles on receiving and imparting information, so basically freedom of expression. And this is a matter that has been the subject of gradual clarification in the convention case law over many years. So there is a clear development, and now we see the court, in fact, referring to a right of public access to documents as well. And here again, very clearly in this case law, also in other cases, but also here, the court again creates an obligation on authorities to say you must apply the convention in a way that makes these rights practical and effective, not theoretical and illusory. So you also have to be concerned about your implementation practices. These rights do not need to exist only on paper, but you actually have to be able to gain access to this information based on the legal framework. There is a new convention, no longer that new, 8 years old, convention signed in 2009 under the Council of Europe framework, which is now being ratified by states. It's now ratified by 8 states, and it will enter into force when there are 9 ratifications, so hopefully soon. But quite a few of the EU member states have signed, and some of them have already ratified. So as of then, there will be, in fact, a convention addressing the public access question specifically. And there, you can have a look at it. It's a detailed convention. I think there is at least one issue here that I would want to lift up, which is the question of public interest, because it seems that in this convention, there is one fundamental difference with the current regulation, 1049, and that is the duty to consider public interest in relation to all documents. And that is an issue where I feel that the current regulation is clearly outdated. We have a public interest test, but it doesn't apply to all the exceptions. And I think this is one more indication of us in the EU needing to make sure that the public interest test would need to apply to all exceptions, irrespective of their substance. Now I mentioned one of the new cases, one of the Hungarian cases, and I know that in several ways the European Convention system is different from the logic of 1049, and then of course you have to think about the ways in which, or sort of what parts of this could be easily applied in the EU context. And since some of these logics are different, not everything might be easy to sort of transplant in the EU context. But I think something that is interesting in this case, for example, is that the Human Rights Court sets a sort of 4-stage threshold criteria for right of access to state-held information. I think these are useful pointers, useful issues to think about when you're responding to a request. The first one relates to the purpose of the information request. And there the court says you should think about the purposes for which the requests were being made. And I think this brings me back to the question of public interest, private interest issue, which is something that the EU institutions have needed to tackle repeatedly, that we get a lot of information requests which in fact are not about public interest, but more private interest. And I think this is an issue that would need to be clarified in the legal framework. The issue is not, I think, simply to say you cannot do private interest requests under 1049, simply because in that case there is no avenue for making these requests. The way of addressing this issue is making sure that there is also an avenue for private interest requests, and that these are appropriately tackled somewhere else. But in a way, when you're thinking about the logics of 1049, it does have a purpose, and that is private interest related information, making that publicly available. Then the court talks about the nature of the information that is being sought, and again brings in the public interest test. Is this something that where disclosure would provide transparency on the manner of conduct of public affairs on matters of interest for society as a whole, and allow participation in public governance by the public at large? That also, I think, links partly with the previous question. Then the court has been relatively big on the role of the applicant, and I think this is, again, something that would be difficult to apply in the EU. The court in Strasbourg has often looked into who has been applying and saying that journalists, NGOs, academic researchers, also more recently bloggers, and users of social media have a very special function because they're watchdogs of the society and have a need to sort of, and have a role in making information available. This would be difficult in our system, which clearly builds on the idea that anyone can make a request and you don't need to reason it. But of course also links with the idea of public interest and freedom of expression and making those grounds more explicit. And then the court talks about whether the information is ready and available. And I think more from the point of view that if it is ready and available, then there really is no excuse for not handing it out. And this links with the questions of data management, because I think often we might face a situation in the EU institutions where information is not readily available, but this could be linked to simply management systems not being all that up to date. And then, of course, the question is, should this be an excuse that it's not readily available? And I think, in a way, the way I read the court's reasoning is not offering this as an excuse, but more as a reason to make it available if it's ready and available. But I think it's a useful reminder of also the need to make your data management systems up to date, and also design them from the point of view that information is also, in practice, easily available. And then again, as in all jurisprudence from the Human Rights Court, the court applies a test for looking into whether interference with rights under the Convention have been justified. This is a three-stage test that everyone familiar with the Convention will know, but the court looks into whether the restrictions have been prescribed by law, whether they're pursued in one or more legitimate aims, for example, the protection of interests of others. That's typical in, for example, data protection system, that you need to do a balancing between the rights of those whose information is being made available and the public interest in making it available. And then finally, the court considers whether it would be necessary in a democratic society. And I actually think the final point is extremely important and something that we should think much more about in the EU. What is the function of public access in a democratic society? Where I think we have a risk of turning slightly too bureaucratic from time to time and think too much about the interest of the administration and too little about the democratic aims of the regulation. Now, having said this, I'd like to come back to where I feel in particular that the implementation of the regulation could be improved and also should be improved with all of that in my mind. And I think it is obvious that the regulation does build to a certain extent on a different logic. And there, of course, one question is whether this logic is sustainable, whether these differences are justified. Are there perhaps something that we would need to consider getting rid of when looking at the regulation, if it's ever open for review again? But there are elements, as I said, which would be difficult to apply. For example, looking at the role of the applicant, which is clearly forbidden under the current regulation. But there are many of these general principles that I think would seem applicable. In particular, the need to evaluate the information for the purposes of public access in democratic society. And I think it is in particular here that I feel that the institutions sometimes do fail rather miserably. And this also shows in court jurisprudence, in particular in the area of legislative matters. Then there is the question of public interest, which is very strong in Strasbourg jurisprudence. There I definitely, as I said, would see a need to introduce these issues to all exceptions, and also do more differentiation between public interest and private interest, which would need to be tackled somewhere else outside this regulation. There are two instances where I feel that the EU regime in particular falls under or falls clearly below the European Convention standards. And the clearest example is the issue of privacy. As I said, this is something that the institutions did consider when looking at in the context of revising 1049. And there we basically have a few lead cases from the Court of Justice, especially the case of Bavarian Lager, which creates a system where individuals are required to basically give their consent to handing out any of their information. And this is something that I doubt that the Strasbourg court would accept, because the court does make a clear difference between the sort of private sphere of individuals and their, for example, their professional activities. There is a very clear case law from the court looking at public figures, politicians, people operating in professional roles, also celebrities, and questions relating to their private life and their public life. And there the court has been very clear that public figures should not be able to censor the press, for example, in the name of privacy, and that professional issues relating to their professional activities should be made public. And also that these are the type of people, if you have a public function, if you're a member of a parliament, for example, you should be able to foresee that when some information relates to your work, your professional activities, acts that are related to the use of public funds, for example, you should be able to assume that that information can become public, and there is a public interest in that information. There are several relevant EU cases pending that are very interesting in this area. There is the MEP project, which looks into the use of MEPs of expenses. There is another one relating to commissioners' expenses, which again I think are very clearly related to their public functions, the use of public money, where I do not see that privacy or private life is an issue. And then again, when it's something that is genuinely related to people's private lives, for example, how they wish to spend their salary, it's a private issue, and then of course that should be protected. But there are elements that I think our protection of privacy reaches too far to issues that are not related to privacy at all, but public functions that should be publicly available. Another issue that I've been worried about for many years relates to court documents. And that's another area where we see one of these general presumptions that I mentioned earlier, basically saying that all court documents relating to pending litigation should be secret. And the problem there is that there isn't really a legal avenue for making these requests either. There is some new case law on this, the Breyer case, and you will hear more about that later today. But I think this is a very sort of fundamental issue. We in democratic societies, it's a key principle that you have public, free and fair trials. And now we have a European Court that basically litigates in secret. And that is a big issue. The fact that there might sometimes be a public hearing doesn't do away with this problem, because most of us will not have a chance to travel to Luxembourg and hear these cases. And for this reason, I've been looking at the rules of the European Convention, or the European Court on Human Rights, and how it deals with its own litigation documents. And it seems that they do apply exactly the same principle of openness that they would apply to everything else. The idea there is that everything should be open. And then if there is a harm, if there is a reason not to disclose everything, then you refuse disclosure. But the main principle is that these documents should be publicly available. And it's a part of the idea of having a public court, public proceedings, and public pleadings as well. And this is something that I think certainly would require work in the EU as well. Another issue that has surfaced, I think, increasingly relates to the Aarhus Convention. That is an international obligation that the EU has relating to environmental information and making that available. We've got many reports from the Aarhus Convention compliance bodies which say that the EU is not up to the standards, and we're not applying the Aarhus Convention correctly. So that is an area, and that is also an area where you see that the relevant secondary legislation in the EU is slightly conflicting as well. So it's difficult to manage. There is some better case law on this, but still this is an issue that would need to be tackled quite urgently, and I think definitely so, since there is an outside body telling us we're not up to the standards. Another issue that I've been looking at recently relates in particular to agencies, because agencies manage huge amounts of information and also huge amounts of public information requests. And I think an interesting area that I've been looking at recently relates to all these different procedures of authorization and approval that the agencies are involved in, where individual companies have an obligation to submit information about their products, for example, for the purposes of receiving an authorization or an approval from an EU agency. And there, of course, the issue is that these information, these documents that private companies need to produce include vast amounts of commercially extremely sensitive information, which obviously not only the big audience, but also their competitors are very interested in getting their hands on. And there is a great deal of discussion about this, also pending court cases, ombudsman cases on this practice. It's an extremely important area of managing risks, not only health risks, for example, but also competitive risks, but also an area where we do have great public interests being involved in this information becoming available. Agencies have tackled this issue in many different ways. One of these is a development that I am concerned about, which I see as a sort of new ownership rule, which basically indicates that agencies have entered very long discussions with private companies on what they consent on becoming public. So in a way, these companies have become the actors that decide on public access, more or less on behalf of the agencies themselves. This is not the way the public access regime should work. It's always the institutions, it's always the agencies who are in charge of making these decisions. But this also, I think, I have understanding for the agencies trying to manage this issue, because it's a very hot issue and it's a very big public interest issue. And I'm not even sure whether this is an issue that the agencies should be tackling themselves. This is an emerging area that would need to be looked into, and where we do have also conflicting legislation, in the sense that the agencies have special rules in their founding regulations, which are not always in line with 1049, and also creates questions of how this should be managed in practice. Then we have, as I mentioned in the beginning, questions again on the applicability of EU legislation or national legislation, which I also see as a sort of growing problem in cases of shared management. For example, in agencies, management bodies, you very often have national authorities sitting. So they are a part of the decision-making structures of an agency, but they are also national authorities. And often very uncertain about what rules they should in fact be applying when receiving requests for information. Should they go for their national rules, or are they prohibited from applying national legislation because of the provisions of EU legislation, in particular rules of professional secrecy? Another issue that came up just last week, I was asked about databases, because there are many EU databases that national authorities in fact have access to and that they are able to use. So would those then need to count as national documents, in the sense that these are documents that can be made available by national civil servants, yet they are documents and information that are with an EU agency, and it's a database that is maintained by an EU agency. So again, a question of definition there. Where does the sort of limit go between EU law and national law? In our case, it's always usually a question also of a more restrictive EU regime and a more liberal national regime. And then, of course, national authorities being concerned about breaking EU rules of professional secrecy. One more big area that I see relates to publicity of procedures. And they're an area that I've been writing about quite a lot recently, relates to legislative procedures, which is an area that the European Ombudsman has been very interested in recently, also an area where we see court cases pending. The big question there relates to trialogues and making trialogue documents available. This is one example of an area that isn't really properly addressed by the legislative framework. We have a Treaty of Lisbon which says legislative procedures should be open, and then we have a regulation which has sort of relatively open-ended principles, but nothing very detailed about the stage of discussions or what areas should be in fact protected. So what we see is that we have a great deal of institutional rules. We've got rules of procedure, interinstitutional arrangements made between the institutions on how they wish to apply the rules. But the legislative framework as such doesn't really properly address this question. And this is an area where I see quite a lot of room for improvement. It's tied to the question of joint register, which I think you will talk about tomorrow. So I just want to flag that out as an area where I would want to see some progress. Then the key issue, I think, to remember is that public access is not about communication. They are two separate issues. And I think, for example, with the trialogue issue, we're very easily tempted to say we don't need public access as long as we communicate, as long as there is a proper communication policy in place. But they're not the same thing. And there is a very fundamental difference between the two. In a communication policy, it's the institution that is in charge. It's the institution that controls the information and decides when it's made available and how it should be written for the purposes of communication. In a public access regime, the idea is that it's the citizen that is in charge. That citizen decides what information it needs, what is important, and also the idea is that you go for the genuine documents that are not modified for communication purposes, but are the real documents that form the basis of discussion. And that is a very fundamental difference. You cannot replace public access with communication. And then the question of good data management, and I think this is an area where we really would need to see much improvement, because information in the EU really is not easily available. And I know many researchers that simply struggle with the fact that they don't even find the information that would be publicly available because the registers are not working. And the Commission, for example, doesn't even have a comprehensive register where you could find documents. The Council is much better on this issue, but even there, you need to know quite a lot about the document in order to find it. Often Google does a better trick than a formal register. And this is an area where I've got some of my own cases pending relating to documents that I haven't been able to find. This is my final slide, and it relates to the question of harm. And this is something that I've been thinking about a great deal when writing during the past months, in particular about legislative matters and transparency. And for that purpose, I did make several requests for documents, and I also studied quite in detail the argumentation of institutions when they are responding to individual requests in this area. This is the matter that the court has addressed in several leading cases. DERCO is one that relates to legal advice, and the second one, Access Info Europe, relates to publicity of member state positions, where I think the court has been very clear on saying harm is very difficult to demonstrate in the context of legislative matters. But still, when you study the argumentation, and also I've made interviews with policymakers, with people working in the institution, there is a great deal of concern about transparency slowing down things, and transparency making matters work less effectively. A feeling that the institutions need to be protected from civil society, and the institutions need protection from citizens, which are a sort of outside distraction. Also those saying, well, if we open up these procedures, it would then mean in practice that the Commission proposal will not be approved, which I think is a terrible argument to be making. A legislative procedure is there for the purpose of debate and looking at different alternatives. And I think it's a very dangerous road to go down on if we start thinking that citizens are a distraction and institutions need protection from them. I do understand that there are legislative files, for example, that are specifically urgent, that you need legislation on something that needs to be urgently addressed, or that you have an instance where, for example, the court has annulled a piece of legislation that needs to be replaced. And then there, of course, is a need for urgency. But I'm not sure whether that is such an overwhelming argument that you can use that for the adoption of legislative documents overall. And of course, in individual responses by institutions, you see some of the institutional thinking, but I think this is relatively widespread, and it's a mindset that I'm tremendously worried about. I don't know what will be needed to change it, but I think it also links with the court's case law from Strasbourg, which I talked about earlier, the idea of public interest and the idea of democratic society. And the idea is that public access has a vastly important role in democratic society that we shouldn't undermine by making arguments that I think in that type of discussion should not be flying.